Uh, Good evening, everybody. Nitin, I will certainly bring this to the attention of the management. Abhishek, firstly, the change in cadre deputation rules, as far as your specific syllabus is concerned, is not important. You'll probably mention this in one line towards discussing center-state relations. Of course, it will adversely affect it and could be looked at as a point of view from combative federalism. Let me come to that and then we'll discuss this in detail. Alright, so in our previous class, we had finished certain PYQs and layer 1 of the prelims part of fundamental rights, directive principles and duties. Now we will get into layer 2, look at certain thematic issues and of course cover with certain doctrines towards the end of it all. Okay, so let's start now. Alright, now as you know, this is part 3, fundamental rights, and as you are aware that we have already, okay, there's something wrong with this, right. As you're aware that we have already covered Article 12, which is of course in the context of what is state. I'll open this in the browser, it will be easier, I think. Right. This is better. Now, right. Now let's understand what it is that we're going to be covering. Okay, so let's start. Part 3, fundamental rights. We had covered the definition of state. We'd understood two things. One, how the judicial side to judiciary is not state under Article 12, and we had also understood how the administrative side of the state of the judiciary is state under Article 12. Right now, the judicial side to the to judiciary is not state as per Article 12. The administrative side to judiciary is state as per Article 12. Now, as far as Article 13 is concerned, we will come back to Article 13 in due course of time when we discuss the doctrine of basic structure and the doctrine of harmonious construction. I believe it is appropriate to now start with Article 14. Now, we are going to be discussing the right to equality, and as I had mentioned before, the right to equality has 4 fundamental rights. We will be getting into each of those in detail and also understand certain concepts as relevant as they are as far as the exam is concerned. Okay, so let us start. Let's understand, when we look at rights pertaining to equality, we are going to be covering Articles 14 to 18, where we understand Article 14 covers two things: equality before law and equal protection of law. 15, as we discussed, is a non-discrimination article plus reservation on the basis of education. 16 is reservation on the basis of employment, and then we have 17 and 18 Please understand this. 17 is with respect to untouchability and 18 is with respect to abolition of titles. Let's begin with, in my opinion, the most important equality related right. I'll take you back to the slides and tell you what it is that we are referring to. Okay, so let us start. Article number, the title of the article, equality before law, and then the substantive text. This does not have any subclause, and the smaller the article, the more wide are its interpretations. Okay, the state shall not deny to any person. This means this right is available to citizens as well as foreigners. That's the first concept that we understand. Second is they use a term called equality before law, and they mention something called equal protection of law. So equality before law has three very direct concepts in it. One, that it is available to citizens and foreigners. Two, it talks about something called equality before the law. And three, it talks about equal protection of the laws. We're going to cover all of this in the relevant amount of detail. Okay. Now, very recently, this year in the 2021 mains exam, there was a question on Article 14, but from a comparative context. The question was, compare the US and the Indian Constitution in the way that they deal with equality before law, right? And this was a question which surprised a lot of students, but if you actually understand the explanation of it, you'll understand that there isn't a lot of difference. It is actually the same thing, but with a little bit more of context. Okay, so we'll come to that. As far as the mains otherwise is concerned, there has never been a question directly on just Article 14, and you must understand why. Because while Article 14 can be violated, it is always violated in addition to something. Like for example, when you challenge homosexuality, no doubt the laws are discriminating on the basis of sexual orientation. Article 14 is violated, but also as Article 19 is also as Article 21. Same goes for transgenders, same goes for privacy, same goes for sedition, same goes for hate speech, same goes for press rights, same goes for journalistic rights, same goes for almost every other rights issue. So it would be appropriate to say that Article 14 will be your support system of right violations, because we understand that in India we follow something called rule of law, and any action which is being executed by the state has to have the backing of the law, and if that action is violating a fundamental right, it is without fail also a violation of Article 14. Okay, so now we understand this. So in the mains, there has never been a direct question on an issue arising out of Article 14, but the only question that was asked in 2021 was compare right to equality between the US and the Indian Constitution, and you will understand why this question was asked very soon. It was never just about the right to equality. Okay, so let us start. Now, when we discuss Article 14 and we mention these two words, equality before law and equal protection of the law, which we abbreviate as EPL and EBL, there is actually a hidden meaning behind this. The meaning has to be understood. Now, let me give you a simple CSAT sort of an example. Okay. Now, if I write this statement before you, which says everyone is equal before God. Let us assume that you believe in God, and we write that everyone is equal before God, and this is my first statement. Then my second statement, which I want to derive from the first statement, if I write that if everyone is equal before God, then I can write that God is superior to everyone. You can only be equal before something because you're giving that something the power to be equal before. You're making that something superior before you. Like, for instance, all students are equal before me. That means that as a teacher, I'm on a slightly higher pedestal than you. Otherwise, we have all forms of equality between us. Similarly, everyone is equal before God means that God is superior to everyone. We could say that, right? Now, this also means that there could be, we are all ruled by God, by God's will, by what God says is right or wrong. Now, very interestingly, if everyone is equal before God and God is superior to everyone, the one thing that we can't do, the one thing that we cannot execute is the fact that we cannot question the existence of God, and we cannot question the superiority of God in this specific scenario, right? In this specific scenario, we cannot question the superiority of God in this specific scenario. That would be a correct way to look at it. All I have to do is replace the word God with law, and one thing changes. If everyone is equal before the law, then law is superior to everyone. That means we should have the rule of law, and what we can do is question the supremacy of the law. We can question the legitimacy of the law. If all of us have to bow down before the law, then the law must be worth bowing down over, right? That is a simple and a very interesting analogy to make. That's exactly what equality before law starts, explains, and deals with. So understand this. The background to this, the foundation of this, is rule of law, which we had understood in our first foundational classes. For the rule of law to be fair, to be just, to be reasonable, for us to be ruled by law, the law has to be just, the law has to be fair, the law has to be reasonable. And for all of that to happen, we must be able to check the law, question the law. And for that, we have two specific ways to go about it, two specific terms. Before we make everybody equal before the law must be worth becoming equal before. That's the basic discussion. And for that, you have two very simple concepts. First, it's called procedure established by law. The first is called procedure established by law, and the second is called due process of law. Due process of law. Procedure established by law and due process of law. Okay. Now let's understand the meanings of both of these. It's important. A very simple way to understand the meanings between the both of this is to actually compare procedure established by law to an arranged marriage, and due process of law to a love marriage. And the differences between the two are actually the differences between procedure established by law and due process of law. So, what are the kind of questions that people ponder over as far as arranged marriages are concerned? What are the kind of questions? First, you look at family compatibility, you look at occupation, you look at logistics, right? Simple. Are the families going to get along with each other? Do they work in a way that is conducive to each other, to support each other, right? And how are they going to manage logistics, day-to-day life, and so on and so forth. But in love marriages, you would usually see more fundamental questions. Like, for example, what are the value systems that both parties believe in? What are their aspirations from life, right? And they get into the technical details. They question the intention, they question why they want to get married in the first place. Are they doing it for the right reasons or not? Correct? That's exactly the difference. So, when you are checking the supremacy of the law, the quality of the law, through procedure established by law, what you are basically checking is if the law has been passed by a valid procedure. If there is a procedure to pass that law, has that procedure been followed? Could be anything. Could be a law, could be an executive order, could be an action of the state. Have we done this properly? Okay. Have we done this properly? Have we followed it in the same procedure in which the law has mentioned? Is the law being passed in the right procedure? For example, if the Lok Sabha and the Rajya Sabha have passed it, the President has assented to it, there was no problem with the procedures, everything has been taken into account, and then the law has been enforced, absolutely nothing wrong with that. It is absolutely okay. And this has a major drawback, which means the contents of the law are not important. As long as the law has been passed in the right manner, it doesn't matter. As long as your families, your careers and your logistics are aligned, it doesn't matter whether you are good for each other or not, whether you are going to help each other grow in life or not. It's extremely important, right? Now, when we talk about due process of law, here we look at two things. First, what was the intention behind which the law was passed? And second, currently, is the law being used for the exact same or for similar reasons that it was passed? Are you using it for the same intentions that it was passed? This is called due process of law. I'll give you examples of both. For example, in procedure established by law, this was one of the arguments that was taken, right? One of the arguments that was taken, and let's understand one of the arguments that were taken. You would have heard of something called the National Judicial Appointments Commission, which was passed through the 99th Constitutional Amendment, which basically meant you had to change an article in the Constitution which mentioned collegium, and you had to replace collegium with that now Supreme Court and High Court judges are going to be appointed through a body called National Judicial Appointments Commission. Once you have done this, then you can pass the NJAC Act and give the details of this. It's like saying pass Article 21A first and then add Right to Education Act. Don't make Right to Education Act before you pass or before you insert Article 21A. That's what we are trying to understand. So what the incredibly intelligent makers of our laws did is that what they did was that they, in a hurry, passed NJAC first and then passed the 99th Amendment, which became one of the grounds for which the 99th Amendment was challenged. Of course, it was challenged on a lot of other grounds also, but this was also one of the grounds under which the 99th Amendment was challenged, right? There are several examples of due process of law. Like for example, Section 66A of the IT Act. Okay. Now, Section 66A of the IT Act was originally inserted in the IT Act because you wanted the government to stop the spreading of online hate, to stop the spelling of Raksham, I don't need you to tell me and stop me and interrupt me in the middle of the class by explaining to me what joint and several liability is. I know what that is, and by the way, what UP government used against CA protesters was also a US principle called Heckler's veto, which was conceptualized by the US Supreme Court in the 60s and the 70s in the Louisiana and the Alabama case on racial segregation. So don't play law with me. I need to teach what is relevant for the exam, and don't get into unnecessary technical details. Don't try to flaunt your knowledge and confuse everybody around. It is a very, very bad habit, because true knowledge will only be justified through humility. Always remember this. The children who don't comment, who listen quietly, who understand, who don't add information unless asked, are always the finest students I will respect the most. Okay? Anyways, so let's continue. So, Section 66A of the IT Act was added primarily because you wanted to ensure that the government was using all possible ways and all possible means to control the spread of online hate. And Raksha, I'm slightly disappointed with you, right? But over a period of time, Section 66A of the IT Act started to being used in a manner where the government used the powers under Section 66A of the IT Act to arrest people who had an opinion against the government, and that was something which was an abuse of the original intention under which Section 66A of the IT Act was actually implemented in the first place. You wanted it as powers given to the government to arrest anybody who spreads online hate. What you ended up using it for was suppressing voices which disagreed against the government, which is why in the landmark Shreya Singhal case, the Supreme Court struck down this specific provision of the IT Act on generally the grounds of due process of law. Okay, so that is something you must understand. So these are the two basic differences. There are several examples. We'll keep coming back to these examples when we do rights issues parallelly. So there is procedure established by law, and then there is due process of law. Now let's understand. So due process of law means the law has been passed with the correct procedure, with the correct guidelines, with the correct mechanism. This is a very mechanical check, and this is more of a qualitative check. Here is the law being used for the right reasons why it was passed in the first place. Now, there are some fundamental differences. The differences are procedure established by law is of course, if you have to understand this in a context, it is explicitly in black and white written in the constitution under article 21. Article 21 says that the state shall not deny life and personal liberty to anyone except otherwise through a procedure established by law. And they've purposely mentioned procedure established by law in 21 because 21 is the most comprehensive and the most open-ended fundamental right. Whereas due process of law is something that we have integrated as a principle, as an idea, because of various Supreme Court judgments. One of the most important ones is the Menka Gandhi case of 1978, which I will discuss in depth a little later because it gives you three very important concepts. One, due process of law. Two, it also gives you the concept of principles of natural justice. And three, it also tells you the relationship between 14, 19 and 21. So we'll cover that later. But this is how through various Supreme Court judgments, due process of law has been made a part of the judicial reasoning that the Supreme Courts can rely upon while determining the constitutional validity of laws. It is also important and extremely pertinent to note that the makers of the Constitution purposefully decided that we will not write this explicitly in the Constitution, but we would write this in the Constitution. And the reason behind this is because intentions are very subjective in nature, and arguments around intentions are equally subjective in nature. So if the Constitution had something which has one second, Abhishek Kumar, I am not your personal tutor. I will respond to your query towards the end of the class and I will get back to you. Please email me and then I will let you know. Okay? So please hold on, and if you are asking a question, please ask that question with the least amount of respect that you can show to somebody who's teaching you and not spamming me in the middle of the class. I hope that is okay, Abhishek Kumar, with the law optional. Anyways, so if due process of law was a part of the Constitution, if due process of law was written explicitly in the Constitution, it would have certainly invited for a plethora of legislative issues. It would have invited a plethora or a Pandora's box of litigations questioning the intentions behind several laws. So the Constituent Assembly wanted to be slightly conservative in terms of the ability of the people to approach the court questioning the intention or the validity of the laws, which is also one of the arguments that was given in the Menka Gandhi case by the government of India, who was represented by the Attorney General. I'll come to that later. But just because it's not mentioned in the Constitution does not mean that it is not a valid concept. And it is the job of the Supreme Court to help evolve the legal system, the constitutional interpretation, and come up with doctrines that can make the entire ecosystem fair. Whether it is the basic structure or due process of law or harmonious construction or colorable legislation or any of those things, right? So that is something that we have to be careful about, and that is something we must understand. Now, if we compare it to arranged marriages and love marriages, we understand that arranged marriages are a more older concept than love marriages. In the same way, procedure established by law is easier to implement, it's easier to keep a check on, and therefore is an older concept than due process of law. Due process of law is credited with the US Constitution and the US judicial system, which in a very exhaustive manner deals with due process of law explicitly in the Constitution as well. Whereas procedure established by law has two origins. One is Japan and the other is UK, right? Now both of them have some context to deal with as far as procedure established by law is concerned. All right. Now that we understand this, if in the prelims they ask you where does due process of law originate from, your answer will very straightforwardly be QS. But in the prelims, they will never ever ask you where is the origin of procedure established by law. In the mains, you can write both of them or either as the origin, you will get the sufficient amount of marks. So what we've understood so far is that before we get into equality and equal protection of law, the story starts with rule of law, which is a Dyson concept. We've discussed this before, which means there are two components to this: procedure established by law and due process of law, which is an American concept, not explicit in Indian Constitution, but evolved through Supreme Court cases or judgments. Whereas procedure established by law is a UK/Japanese concept explicitly mentioned in the Indian Constitution under Article 21 among other articles. This means it was the intention of the Constituent Assembly to include procedure established by law and not due process of law, which was evolved through Supreme Court cases, right? We understand procedure established by law is a procedural check and due process of law is a qualitative or an intention based check. Once the law is good on both of these counts, then the law is fit to rule over us. Now that the law is fit to rule over us, the law must have two extremely important features. One is equality before law. And the second is equal protection of the law. Equal protection of the law is a US concept and equality before law is a UK concept, both of which are a part of the Indian Constitution. Now let's understand equality before law. Equality before law very simply means, and this is very interesting, very simply means everyone should be treated equally before a law or a court of law, right? But this simplistic statement has a lot of manifestations. This simplistic statement has a lot of interpretations and a lot of anecdotes which make it a little more complex. I'll first start with an analogy, a case study which is not particularly related to this, and you will understand this. This case study involves two specific instances. These two instances are one where an army officer, while on duty, performing a routine patrol in a sensitive area, encounters some terrorists and kills a civilian in crossfire and the terrorists. Okay, that's the first, right? The second case study is a young person under the influence of alcohol is driving at a high speed and hits and runs over a tea vendor and kills the person. In one line, and I'm going to give you 2 minutes to think about this. In one line, I need you to tell me the difference between instance 1 and instance 2. In one line, I need you to tell me the difference between instance 1 and instance 2. You have exactly 2 minutes. You have exactly 2 minutes. Okay. So a lot of you have spoken about one was performing their duty and the other wasn't performing their duty. Good. Excellent. The key differentiating factor here is sometimes the job that you do makes you take certain difficult decisions. Sometimes the jobs that you do makes you take certain difficult decisions. The primary difference here is that the army officer was acting in the course of the person's duty. Whatever the army officer did because it was their job to do so, right? Intentions and other cases, it's fine. But this is the primary difference, which makes us understand that I need to apply this course of duty principle to equality before law, which means the same law on murder, because there are people who have been killed. The legal word for murder is homicide, which is killing of a human being by another with the word culpable to it, and the blame can be put. In both the cases, a human being has been killed by another human being and the blame can be put on the other human being in both the cases. But both the cases are not the same. The same law on murder in the Indian Penal Code cannot be applied to both of them equally. That is the point of discussion. So in the course of duty, some decisions will be taken, and because of that, you cannot under any circumstances treat people in the same way. You will have to provide with certain protections to certain people because of what they do, because of who they are, because of how tough their job is. And therefore, we must understand the origin of the concept of immunities. So everyone is equal before the law unless you have an immunity from the law. So the immunities basically become exceptions to equality before law. And there are a few examples I'd like to state before you. So as far as the Constitution is concerned, the Constitution provides two kinds of immunities to two sets of people. One is the immunities given to the president and the governor, and they get the exact same immunities, and the immunities given to MPs and MLAs, and they get the same kind of immunities. Apart from the Constitution, you also have diplomatic immunities, which are extended to official representatives of the people. You also have, in a very limited capacity, certain military protections as well, because they are often also executed in the course of your job. These are not in your syllabus, so please don't bother reading about diplomatic immunities or military protections. Diplomatic immunities actually run through an international convention that India has also ratified, and military protections are in other subsequent laws. But this is not in your syllabus, this is. So let me explain to you how the same things, if done by anybody else, would have been objectionable, but by these people wouldn't be. Now, we all understand that we all live a dual life. We all live a dual life, which means We have a personal side to ourselves and we have a professional side to ourselves. So what we do in our personal capacity versus what we do in our official or professional capacity are two very different things. But you see, for somebody like me, what I do in a personal capacity and what I do in a professional capacity, both of these are somehow private in nature. I'm not a public official, right? But you guys, when you become civil servants, your professional life is your public life. The decisions that you're taking on behalf of the people, for the people, in the best interest of the people. That does not necessarily apply to me. The people of the country, through their taxations, don't pay my salaries. But the people of the country, through their taxes, pay your salaries. So you're a public office. So your responsibility would certainly be different from mine or from anybody else's. Similarly, in the case of the president and the governor, you have both of them acting in a professional capacity as the president and the governor, or in a public capacity, and also in a personal capacity. In a personal capacity, right? Now let's understand this. What happens if you break a law? What happens if you break a law? You either pay compensation or pay a fine, or you go to jail and pay a fine, which means the repercussions are either civil or criminal in nature, or both. And we've discussed the difference between a civil law and a criminal law in our foundation classes. So, as far as the professional or a public capacity is concerned, which basically means any decision taken by the president or the governor in the exercise of their public office, in the exercise of their public or professional capacity, doesn't matter what the decision might be, they have absolute civil and they have absolute criminal immunity from it. For example, let us say the president, it is under the name and the sign and the seal of the president that, let's say, India signed the nuclear deal with the US, also called Section 123. It's because Section 123 of US law gave an exception to India, because India is the only country who hasn't ratified some nuclear treaties and still is being given technology and material support by the US so that they can, use nuclear technology for civilian purposes. All right. Now, very similarly, let us say that the deal gets signed between India and the US, and when the deal gets signed between India and the US, let us say India paid US a huge amount of money, and US is supposed to deliver the nuclear shipments to India in a stipulated amount of time. Let us say the US defaults on their shipment deliveries. That means the US has defaulted. And one of the reasons is that we did not keep a staggered payment mechanism, that you deliver a shipment and then we'll pay later. Everything was not to be done upfront. So obviously India has lost a lot of money. For example, hypothetically, you will not hold the president accountable. The president is not responsible for that contractual default, which is basically civil in nature. Criminal. Let us say we understand that the president is the supreme commander of the armed forces, and let us say war has to be declared, and in the course of war several lives are lost. Has the president personally committed murder? No. The president will have complete criminal immunity for any action that they or the governor take in their professional capacity. But let's say we talk about a personal capacity. So in the course of a personal capacity, what do we understand? We understand that, let us say, the president or the governor did not pay their credit card bills. Let's say the president or the governor did not pay their credit card bills. That is a credit default, and a credit default, you could initiate recovery proceedings, or let us say, a payment was to be made by them, they didn't pay their EMI or whatever, so some default had occurred. Now in such a scenario, when there is such an important issue, then you will give the president or the governor a 2 months notice. You will give them 2 months to clear any civil default, if there is, and only after 2 months can a case be filed against the president or the governor in a civil matter for something that they've done in their personal capacity. As far as the professional capacity, as far as criminal is concerned, the law is very clear on this, and all of this is in the constitution. Very clear it is that they have criminal immunity until they hold office. Until they hold office. Now you must understand why. Why have they been, for example, the president hits and runs, or commits murder, or commits a crime. As long as you are the president of India, no criminal case will be filed against you. The second your presidentship tenure is done, then criminal action can be undertaken against you, and even if any time period limitations exist, or any statute of limitations exist, they will be waived against you. Basically meaning that there will be no time limit, because you were the president and you had certain immunities. So that is why we could not file the criminal case earlier. Now the reason why you have something like this is because, for a simple fact, so that fraudulent or malicious criminal complaints are not filed against the president or the governor, so that they are not distracted from doing their job, right? The other counter is, if the crime which is being committed is of such a severe nature, is unpardonable, is unforgivable, and not a minute should be wasted, then you can immediately, the parliament can immediately remove the president, and through the council of ministers, and the president can immediately issue an order to remove the governor, and then you can start any proceedings that you may want to, as far as that crime is concerned. So this is one of the immunities which are an extension of our understanding of what is called equality before law. I'll give you another example of similar immunities which are enjoyed by our MPs and MLAs. I will do them in detail when I teach you parliamentary immunities as a part of the parliament. I am only giving you this as a reference example. The reference example here is that the MPs and MLAs have immunity for what they speak and for what they speak and how they vote on the floor of the parliament. I am purposefully not giving you the constitutional articles because you don't need to know them right now. We'll cover them later. Right? Parliament or state legislatures or legislatures in general. Let's understand what does this mean. Now, there are two things. First, what they speak and how they vote. Now, this is often in the news. For example, a member of parliament uh, recently on the floor of the Lok Sabha, right? Recently on the floor of the Lok Sabha. By recent, I mean it's still been about almost a year now, less than a year. Mahua Mitra gave a very fiery speech questioning the integrity of the judiciary. Questioning the integrity of the judiciary. Now, she gave that speech on the floor of the parliament. Had she given that speech in a TV interview, or if she had written a tweet about it, then the Supreme Court could have initiated contempt of court proceedings against her. But because she said what she said on the floor of the House, she had immunity. Now, this is also a grey area because even on the floor of the House, you can't discuss the conduct of the judiciary unless you are specifically removing a judge. So, this particular incident was therefore very hotly debated. But the point remains, any other person saying anything similar anywhere else might face contempt of court charges. Contempt of court means two things. There is civil contempt and there is criminal contempt. Again, I will do this in detail later. Contempt of court is in the Constitution, which basically says the Supreme Court has contempt powers over itself and the High Courts have contempt powers over High Courts and all the regional courts within the state. Then we have a dedicated law called the Contempts of Court Act, which defines what is called a civil contempt and a criminal contempt. A civil contempt is if you are not following a court order. A criminal contempt is if you are saying something which is scandalizing the reputation of a judge or the judiciary or the court at large. So in the Prashant Bhushan case, Prashant Bhushan basically tweeted about the conduct of our Supreme Court judge while he was sitting on an expensive motorcycle, which was, I think, owned by a minister or something, and therefore questioning that how is the judiciary supposed to be independent if they're riding motorcycles with their political counterparts. Therefore, Supreme Court initiated criminal contempt proceedings against Prashant Bhushan. If Prashant Bhushan had said the same thing on the floor of the parliament, then you would have not been able to touch. Now you must understand why. It's because as MPs and MLAs, you have a constitutional responsibility to speak the truth and nothing but the truth in your opinion in the best interest of the country as soon as you can, whenever you are given a chance to, on the floor of the House. As an MP or MLA on the floor of the House, whether it's the parliament or the state legislatures, you have a responsibility, you have an absolute unconditional responsibility to say what is in the best interest of the country, even if it hurts the sentiments of any number of people. That is why if everybody else, could be charged with contempt, or for example, ordinary people could be charged with defamation. Defamation is also civil and criminal. It's a criminal offense under, I think, 499 IPC, and civil you can of course go to court and seek compensation. Defamation is either in verbal or non-verbal form. Verbal defamation is called slander and non-verbal form is called libel. Now, if you say something which scandalizes the reputation of any other person and causes damage to the person, then a person can go to the police station and can also go to a civil court and seek damages, right? Now, that is why we must understand this is a problem. Okay, so therefore a normal person saying something defamatory can face defamation, but our beloved MPs and MLAs will not be. These are reasonable restrictions to freedom of speech under Article 19, but these are not restrictions for MPs and MLAs because they have a foundational duty to speak the truth and nothing but the truth. So this is how Article 40, equality before law, actually works in India, right? As far as the exam is concerned, this is all you need to know. This is it, nothing more. Nothing more you need to know, right? Of course, we'll discuss due process of law, procedure established by law, principles of natural justice as correlative explanations towards larger thematic issues, but not at the moment because they are related to the Menka Gandhi case. I'll come to that later, right? So, of course, are we clear with this? Do we understand this, right? Now, similarly, this is a massive constitutional loophole. I've spoken about this earlier also, I made a YouTube video about this also, but this is a constitutional loophole which basically legally allows for corruption. This legally allows for corruption. And I'll explain to you how and I'll explain to you why. Because, and let's understand this, it's because, for a very simple reason, it's because an MP or an MLA cannot be civilly or criminally charged for how they vote on the floor of the house. Under anti-defection, you can remove them, disqualify them, that is okay. But that's not a civil or a criminal punishment. That is not a civil or a criminal punishment, right? And very interestingly, there's a case going on. You may have heard of somebody called Shibhu Soren. Now, Shibhu Soren's daughter-in-law, I think, or daughter, is an MLA in the Jharkhand Legislative Assembly. And some time ago, there was a vacancy in the Rajya Sabha from the state of Jharkhand. And therefore, MLAs had to vote and choose somebody who they think will represent Jharkhand at the Rajya Sabha. Now, allegations are that this person's daughter-in-law took a bribe to vote in favor of a specific person so that the person gets to get the requisite amount of votes and becomes a Rajya Sabha MP. A CBI inquiry was ordered and the CBI found reliable evidence supporting the same. And the CBI initiated proceedings. This case is currently pending in the Supreme Court, where the daughter-in-law's lawyer has very cleverly argued that even if, let us say, she has taken money to vote a specific way in the house, she has immunity as an MLA. So how she votes is not a matter of question. So if it is not a matter of question, then you cannot question her for corruption, and the entire CBI case is therefore baseless. I am expecting a very important Supreme Court judgment in 2022 on this issue, which is going to be a landmark moment in exceptions to parliamentary immunities. Let us see if and when that happens. If not, then of course we'll see when we'll see. But these are basic immunities that are given to people under equality before law. And that makes us understand what is equality before law. Okay? Several forms of immunities can be given. Militarily also you have UPSC and things like that. Now comes the next part. The second term, which is equal protection of the law. Equal protection of the law. Now let us understand what this means here. Your guidebooks, your standard textbooks often refer to words like treat like people alike or treat similar people similarly. but this is actually a little more nuanced in its setup. Okay, chaliye, let's understand what is it that we are referring to, what is it that we are trying to understand. ठीक है, ध्यान से देखते हैं. A simple unrelated example is, let us say there are 100 students in this class, and let us say out of these 100 students, 20 students were unable to understand a few concepts that I discussed in class. 20 students were unable to understand a few concepts that I discussed in class. So for these 20 students, I took an extra class explaining the same concepts which I explained to the 100 students. It would be fair to say that this extra class is not going to be unfair to the remainder 80 students. In fact, it was their privilege and it was their advantage that they were able to understand the class without have to doing it again. This makes you understand that every child is not the same, because every child will have different learning outcomes, will have different learning capacities, will come from different walks of life, and therefore will have different paces of learning. Similarly, Chetram, you have no business commenting on how a person looks. I will throw you out of class and I will make sure that you are not able to attend any class at the institute and your entire fees would be refunded to you. Who the hell are you to tell me to go shave and get a haircut so that I look younger? Nobody has any right to tell anybody how they look. How they want to look is their personal choice. And what is very ironical, Chaitram, is that I am discussing fundamental rights and you are questioning my fundamental right to decide how I want to look, if I want to even make that decision. Extremely, extremely pathetic of you. Anyways, so equal protection of the law, which means everybody has difficult circumstances and people should be treated in the same way for the circumstances that they come from. Right? That's the larger explanation. So let's understand this through a larger example. Let us say there is a JEE advanced exam, right? There is a JEE advanced exam. Now, there is a student A who has attended a fancy coaching in Kota. His or her parents are extremely well off and therefore are able to afford every comfort given to the student A, and the student A has attended an extremely prestigious school as well, which has given this student excellent conceptual clarity. Okay? Understood? Now there is a student B, and let's understand this. Now there is a student B who comes from a community where most people don't even attend school, and under the right to education program was able to finish most of their schooling at a government school with negligible teachers, and is also appearing for the same JEE advanced exam. Okay, all right. Are we clear on this? Both of these students are not the same. Both of these students are not the same. Both of them are not here with the same kind of background and backup like anybody else, right? We must understand this. They don't come with the same background. They don't come with the same backup. So, it would be unfair for both of them to get the same cutoff when they were not able to get the same preparation for the exam. I hope now you're understanding what I'm trying to hint towards. I'm trying to hint towards a policy of reservation. That policy of reservation, that policy of treating people from a specific set of circumstances in a specific way, right? Originates from equal protection of law, both a part of US and Indian constitutions, and this gives birth to affirmative action as a concept, where the state has to take certain additional measures to specifically uplift certain specific sections of society. Okay? Yes. So one can say that the constitutional philosophy of reservation actually originates from Article 14. Article 14 tells you that you can reserve. 15 and 16 tells you how to reserve. So the foundation of reservation, as we would know it, actually comes from Article 14. Extremely important, right? And this is not just true for reservation. Any form of comparative difficulty. For example, you would have heard of something called special category states. It is unfair for states in the Northeast and the Himalayan region to share the same financial burden for schemes which are jointly to be operated. That is why for schemes which are jointly funded by the center and the states, there are exceptions to the northeastern and the Himalayan states where 90% to 100% of the expenditure is borne by the states. 90% to 100% of the expenditure is borne by the states. Okay, so special category states is actually an example or a correlation of equal protection of law, but because fundamental rights are specifically about people, so reservation becomes your most likely outcome, right? So this is what it is. This is what Article 14 is. This is what Article 14 deals with. Okay. Now you can take a 5-minute break, consolidate your understanding of Article 14, then we will start with Article 15. And I'll actually do this 15 and 16 together. It's actually very easy and it's very simple to be done. Chaliye. Class will be ended at 8:50. Kerala Assembly vandalism judgment is for parliamentary immunities. Cover that later. All right. Now we are going to discuss Articles 15 and 16, and I would like to discuss Articles 15 and 16 together. Now please understand why. Because Article 15 and 16 collectively cover two things. First, non-discrimination, and second, reservation for education, and this is higher education. Please understand, school education, that reservation comes under Article 21A. The grounds for school education reservation are completely different for higher education and government employment. Okay, these are basically the things that Article 15 and 16 explain or tell us what they are about. Okay, so let us start and we'll keep coming back here. All right, now let's look at Article 15 and the prohibition points. Article 15, your title is Prohibition of Discrimination on Grounds of Religion, Race, Caste, Sex or Place of Birth. An easy way to remember this is C, R, R, S and P. Crisp. You can rearrange the order, that's fine. But religion, race, caste, sex or place of birth. Every word has a specific meaning. Now let's start. Article 15 clause 1 says, the state shall not discriminate against any citizen, which means this is a right available only and only to citizens on grounds only of, now remember this is the second point, only of religion, race, caste, sex, place of birth and any of them or any of them. Now what is this supposed to mean? I'll tell you what this is supposed to mean. When we are talking about Article 15 clause 1, we understand that it is for citizens only and the grounds that are mentioned are CRRSP. You can change the order, that's okay. Caste, religion, race, sex or place of birth. Now there are two words that are mentioned. First, the word called only and the second word is called any of them. What do both of these words mean? It means you cannot discriminate against any citizen only on the basis of these grounds, which means if there was another factor X and that other factor X was not CRRSP, you can discriminate. So you can't discriminate only on this. So you can't discriminate on CRRSP. This is not allowed. And C plus R plus R plus S plus P, any combination is not allowed. What is allowed is C plus X, R plus X, R plus X, S plus X, P plus X, as long as X, as I said, is not CRRSP. Okay? This is what is basically meant by Article 15 Clause 1 here. Okay? Now, we'll discuss the rest of the matters here. Alright? So, this is how it works. Now, Article 15 Clause 2, an extension and an explanation here. No citizen shall on grounds only of religion, race, caste, sex or place of birth or any of them be subject to any disability, liability, restriction or condition, which means you cannot be stopped, you cannot be penalized, you cannot be restricted, there cannot be any there cannot be any terms and conditions to these matters with respect to what? I'll just tell you what this is. Now, see, the first thing I must tell you under all circumstances here is this. This is very socially contextual at that time. It says, on the basis of C, R, R, S, P or C plus R plus R plus S plus P, you cannot be stopped from access to shops, public restaurants, hotels and places of public entertainment, right? Which means, what if restaurants have a dress code? What if restaurants have a dress code? Then what are you going to do? What if restaurants have a dress code? That dress code is plus X. So legally, restaurants can stop you from entering their premises if there is a dress code. Very recently an incident had happened where a lady who was wearing a sari was not allowed to enter a posh Delhi restaurant. She of course spoke very publicly about it, and then the municipal corporation, the NDMC, the Municipal Corporation of Delhi, either of the two, cancelled the restaurant's license or suspended it for some time. That was not because of the dress code. That was not because of the dress code. That were some other food and beverage violations that they dug out from the hundreds of violations that we have, right? So that plus X principle applies here. Like a lot of times, restaurants don't allow people who wear sandals or chappals. I have been stopped multiple times in places here. Okay, so this is something which is a general provision. Now, if you notice carefully, Article 15 Clause 2 Subclause A, when we talk about shops, public restaurants, hotels and public entertainment, they can be privately owned, right? So just on the basis of this, even private shops, private restaurants, private hotels, private places of entertainment, they can't stop you. But plus X is allowed. This is a very socially and a very historically contextualized provision, which says use of wells, tanks, bathing ghats, roads, places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. This is largely because of casteism in India, where people from lower castes were not allowed to use the same wells, the same water tanks, the same bathing ghats, were not allowed to walk on the same roads, were not allowed to enter the areas of, public recreation like parks or monuments and stuff like that. So this has a lot of reminiscence to the caste practices that were extremely prevalent in India, right? So that is that. Now, this is Article 15 Clause 2. Very simple. 15 Clause 2A is about government and private. 15 Clause 2B is about government, right? These are about government. Okay? Understood? Now, 15 Clause 3. 15 Clause 3, in a way, is an exception to everything else. That the government can make certain special provisions for women and children. Nothing in this article shall prevent the state from making any special provisions for women and children. This is nothing but an application of equal protection of law, as these are vulnerable sections who have been historically disadvantaged. Okay, who have been historically disadvantaged. So, Article 15 Clause 1 and 15 Clause 2 are manifestations of equality before law. But Article 15 Clause 3 is a manifestation of equal protection of law, right? A manifestation of equal protection of law. Do we understand this? Is this okay? Is this clear, everybody? Yes? Now, this is up until here, non-discrimination ends. Article 15 Clause 3 is the bridge between non-discrimination and affirmative action. That you will not discriminate against anybody, but for people who really need it, you should positively discriminate. You should positively discriminate. Okay, you should positively help them out, because equal protection of law, which comes from affirmative action, says that as long as your classification of people is reasonable, as long as why you are creating the classification and what you are doing for that classification, if that's justified, it's okay. Like, for example, it is reasonable to say that people from lower castes in India have been historically prevented from equality in society. So, if you give people from lower castes in India a lower cutoff for government jobs, that is justified enough, because people from lower castes in India historically were not getting government jobs. They were not able to enter government jobs. So giving them reservation in government jobs is a rational nexus, and the classification is reasonable. Alright, so that is it. So Article 13 becomes your bridge between non-discrimination and what is called reservation. Right, now we'll come to Article 15 Clause 4. Article 15 Clause 4 is actually from where? Article 15 Clause 4 is actually from where reservation sort of begins. Okay. Now, interestingly, this is just to give you some context. Article 15 Clause 4 was not a part of the original constitution. Okay. This Article 15 Clause 4 that we are talking about, this part, was actually added in the very first article of the in the very first amendment of the Constitution, which is the first Constitutional Amendment Act, right, of 1951. It is something that we will, look at in a grand amount of detail later on in the context of land reforms and basic structure. Okay, understood? State, Adarsh, state. Now, nothing in this article or in clause 2 of the article, let's start. Nothing in this article or in clause 2 of article 29 don't worry about this, this is about minorities, shall prevent the state from making special provisions for the advancement of any socially and educationally backward classes of citizens or for scheduled castes and scheduled tribes. This means Article 14 adds to women and children. So originally it was women and children, then within the first year itself, now it becomes women, children, socially backward, educationally backward, scheduled castes and scheduled tribes. Scheduled castes and scheduled tribes. Okay? Understood this? Are we clear with this? Do we understand this? Yes or no? Yes? Pakka? So we have expanded our discrimination. Okay? Understood this? Now the constitution remains silent, and after decades and decades we come with Article 15 clause 5, which was also added later to the constitution, and Article 15 clause 5 was added through the 93rd amendment of 2005. Through the 93rd amendment of 2005. So just imagine 1951, 2005. Just look at the gap of development. I'm going to come to that. This article says, nothing in this article or in subclauses G of clause 1 of article 19 clause 1, don't worry about it, shall prevent the state from making any special provision. The most important part, by law. This has to be done by law for the advancement of any socially and educationally backward classes of citizens or scheduled castes or scheduled tribes, insofar as such provisions relate to their admissions to educational institutions, including private educational institutions, whether aided or unaided by the state, other than minority institutions in clause 1 of article 30. Basically इस इतने बड़े पैराग्राफ का सिंपल मतलब ये है कि SC, ST, सोशली एजुकेशनल या सॉरी एजुकेशनली बैकवर्ड, सोशली बैकवर्ड क्लासेस के लिए हम एजुकेशन में रिजर्वेशन दे सकते हैं, राइट. दिस इज थ्रू द 93rd कॉन्स्टिट्यूशनल अमेंडमेंट 2005. इससे पहले we've already had the 86th constitutional amendment of 2002, which has added the right to education, which gives you reservation through the Right to Education Act by law for school education. तो यहाँ क्या बचा? Higher education. It basically says you can make a law giving reservation in government and private educational institutions except minority educational institutions. Minority educational institutions में reservation नहीं लगेगा, कॉन्वेंट में नहीं लगता, मदरसा में नहीं लगता, right? That's the basic explanation. The government and private educational institutions, reservation can be applied to both except minority institutions on grounds of SC, ST and socially and educationally backward classes. We call them as OBCs, other backward classes. ठीक है? Understood this? Are we clear on this? कितना सिंपल है कि SC, ST, OBC के लिए हम प्राइवेट स्कूल, प्राइवेट कॉलेज, गवर्नमेंट कॉलेज में रिजर्वेशन देंगे, बस. एंड इस पे सुप्रीम कोर्ट विल ऐड ए जजमेंट, इंदिरा सोनी, that reservation will not be more than 50%. Bas. This reservation will not be more than 50%. Bas. It's that simple. Nothing else. And you cannot apply reservation to minority institutions even if they're funded by the government. That is it. Simple as that. Right? This is Article 15, Clause 5. Then Article 15, Clause 6 was added. Article 15, Clause 6. Okay? I'll just come to this in a minute. ये देखो, इतना ताम झाम लिखा है, बहुत सिंपल है यार. Article 15, Clause 6, added through the 103rd Constitutional Amendment of 2019, and your antennas would have shot up. This means EWS. Exactly the same things. It means nothing in this article or anything except 19 and 29, isko bhul jao, will prevent the state from making any special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in 4 and 5, which means SC, ST, OBC, इसके अलावा EWS. बात खत्म. Any special provision for the advancement of any economically weaker section other than the classes mentioned in 4 and 5, insofar as such provisions relate to their admission into same drama educational institutions, including private educational institutions, whether aided or unaided, other than those mentioned as minority, in which case this reservation should be in addition to the existing reservation and subject to a maximum of 10%. Subject to be a maximum of 10%. Bas. Are we clear in this? Understood? Right? Bas. Itna hi hai. And what is EWS and what is not EWS? This will be notified by the government from time to time. If I remember correctly, they've already given an explanation to this. नीचे ना इसका कॉन्स्टिट्यूशन में उन्होंने एक्सप्लेनेशन लिखा है. ठीक है, देखो 103rd और ये सब, ये देखो. फॉर द पर्पस ऑफ दिस आर्टिकल एंड आर्टिकल 16 पहले लिख दिया, EWS shall be in such a way may be notified by the state from time to time on the basis of family income and other indicators. बस. कहाँ रिजर्वेशन कॉम्प्लिकेटेड है भाई? कहाँ रिजर्वेशन कॉम्प्लिकेटेड है? This simply means what now? This means as far as education reservation is concerned, we've got two kinds, school and we've got college. School education is governed under Article 21A plus Right to Education Act. Article 21A was the 86th Constitutional Amendment 2002, and RTE has 25% reservation on the basis of EWS. इसका अपना अलग definition है, इसकी अलग कहानी है. College, government and private, and this EWS is for private, by the way. Government and private, it will not apply to minority educational institutions. Here you will have SC, ST, OBC. इसमें हमने OBC में नॉन क्रीमी लेयर ऐड करा है, and you have EWS. This reservation is not supposed to be more than 50%, and this is about 10%. बस. इसमें कहाँ दिक्कत है? कुछ नहीं. बस यही रिजर्वेशन है. ये 50% क्यों? Because of the Indra Sawhney judgment, which is why EWS has been challenged in the Supreme Court कि भाई आपने ये तो निकाल दिया. So this means general will now get 40%. Okay, general will now get 40%. Horizontal and vertical reservation apply to employment वो मैं आपको बाद में बताऊंगा. I'll put all of this together in a big table for you and show you tomorrow. पर इतना ही तो आसान है 15. इसमें क्या टेंशन है? इतना ही तो है बस. कौन पूछ रहा है एग्जाम में इससे ज्यादा? कोई नहीं. In addition to existing is this: SC, ST, OBC is 50%. EWS is in addition to this 10%. Okay, understood? Government schools don't require private reservation. Government schools under RT will have maximum admissions anyway. Navodaya is a government school, beta. Of course, creamy and non-creamy layer I will explain after employment reservation. Okay? They have added an economic component here. This is purely economic. This is social, economic and educational, and this is primarily social and educational. The grounds on which this is decided. I'll cover this, don't worry. Okay? I'll cover the whole thing, don't worry. The basic explanation here is SC and ST reservations are Indic reservations. They are only given to the Hindu, Buddhist, Jain and Sikh category. OBC reservation is for all religions, and EWS is also of course for all religions. Technically, religion is never a criteria for reservation. It is social and educational backwardness. SC, ST is social and educational backwardness. This is social, educational and economic. This is purely economic, right? SC, ST lists are maintained nationally by the center. OBC, you have separate lists for center and separate lists for states. EWS, for that specific, you will have your criteria. We'll cover this, right? Thank you, Adarsh. Okay? Understood this? Are we fine with this? Right? Yeah. So this is how it is. 15 clause 1 is that simple. Okay? Clause 6 of Article 15, whether making special provision. If no, then how far the jump from 15 clause 6 is over and above the existing provisions of 15 clause 5. Abhishek Kumar. Yeah. Alright. Thank you. I'll see you tomorrow. Yes, military schools also. Yep. We'll cover this. This is just the introduction to it. Thank you.